So this is a Walmart injury that happened in West Virginia, and it's again there's another theoretical. How is this case treated in Walmart versus or Walmart in West Virginia versus how might it be treated if you got injured as an employee at Walmart in Ohio? Because it depends on which state you're in. That tells you which law applies. So there's a West Virginia workers' comp claim, and it's interesting to see compare and contrast. So what ended up happening is this injured worker allegedly got injured on March 16th of 2023. He or she then went to the hospital and they filed the equivalent of a first report of injury form in West Virginia at the hospital. And in that West Virginia first report of injury form, they indicated that they got injured. The injury occurred from lifting heavy stuff all day long. So that's March 18th. They filed that. They went to the hospital and they filed that. And then on April 27th of 2023, they filed an associate incident report. And on that form, they indicated how the way that they got injured was he lifted a bag of dog food and did something to his shoulder. So the March 18th, they indicated injury occurred from lifting heavy stuff all day long, and then April 27th indicated he lifted a bag of dog food and did something to his shoulder. And then the workers' comp board of West Virginia divided the claim, and they filed the claim to the court, and the court affirmed the decision of the West Virginia workers' comp board. And basically, the whole issue with that was that I guess the inconsistencies, and they also applied some case law. So I don't know if it got summary judgmented out. Summary judgment basically means that there's no facts or evidence that the non-moving party so if you're the defendant filing a summary judgment, which would be you, the employer, saying the employee has no case because of they don't have the evidence to show X, Y, and Z. And if there is no evidence, then the court will just say, okay, you lost, and we're granting the summary judgment motion, and we're giving the win to the employer. So maybe that happened. I don't know. I didn't actually read the underlying case. I'm kind of reading the summary of it, but it's kind of interesting the issue with the inconsistencies. And the reason why that's interesting is because that happens all the time with injured workers that I encounter in Ohio. So how would Ohio determine this injury, or how they would approach this injury? I also think, depending on which hearing officer you got and how you testified, that this could go both ways. It could be allowed in the sense that if the injured worker just said, hey, I didn't necessarily say that to the hospital, this actually is what happened, or in fact, what I said to the hospital was what happened. I don't know why, this was written on the incident report. And you might that injured worker might have qualified and say, I actually told my my manager that I was lifting dog food all day long, bags of dog food. So when I meant heavy stuff, that all day long, I was lifting dog food all day long. And when I said I lifted a bag of dog food, that meant to say I really meant what should have been written is I was lifting bags of dog food all day long. I don't know. Point being is, anytime there are inconsistencies, it's you just don't want it. It's just not a good thing. But so alternatively, the hearing officer at the industrial commission, they might say, I'm not buying this. You're changing your story, or maybe I don't know. Whatever you argue to explain the inconsistency, you're always coming from a weak position. You really want to be consistent. But so that's how it would be treated at the industrial commission level. If it's a denied claim, you'd file a 512 case, or you'd have the opportunity to do so. And I think you'd have a better chance. I don't know how West Virginia civil court is, but I think in Ohio civil courts, you would have a better opportunity prevailing, Because instead of a single hearing officer determining your situation, you're going to have, your jury members who happen to be normal human beings. And I'm not saying that hearing officers aren't normal human beings, but meaning the jury members you're not going to have a jury of industrial commission hearing officers, essentially. So you're going to have jury members who might also work at Walmart. They might also do labor jobs. You might have office workers. You might have all people from all facets of life, but they're going to come at it from a more of a sympathetic kind of situation, assuming the injured worker comes across trustworthy, and if you're the injured worker and lo and behold, in your background you committed some kind of felony involving forging fraudulent checks or stealing people's identities, you're not going to be super trustworthy. That's going to knock against you. So you got to weigh what's going on. But generally, I think you might have a better opportunity, and you very well may win, even though there are inconsistencies in this situation. Because I've encountered that where the claim is denied administratively and then it's allowed by the jury at a court trial. So that might happen in this situation, assuming it doesn't get summary judgmented out. I don't see where summary judgment would apply in this situation. I don't see how that would work. Usually summary judgment is like I don't know, like a good example, but maybe like a going and coming type situation, and you really don't have any evidence to prove that any of the exceptions apply. I'll have to come up with some examples for a summary judgment when that's granted in the context of workers' comp cases, maybe in a future video. But so this injury was denied in West Virginia court. I think it might be allowed in Ohio, assuming everything else was okay, like i.e. you're not like a convicted felon for some kind of fraud or integrity type crime. I think you might win. So anyways, that's West Virginia versus Ohio. Again, at the end of all these videos, I always tell everybody, do not do this workers' comp stuff alone. You're going to shoot yourself in the foot if you think you can do it alone. At the very least, consult with an attorney. Because here's the thing, we'll have people call and they'll ask, do I need an attorney? And we will tell them, you know what, at this point in time, I think you're okay, But the point is, they've consulted, they've reached out to an attorney, i.e. they've reached out to us. I'm assuming that's occurred with other law firms, but we might very well say, no, I actually think you're okay. I think your situation is okay. I don't think you need an attorney. But definitely consult with an attorney, and in fact of the matter, unless you're a prospective attorney or attorney, you say, yeah, I think you'll be okay. I think you really always need to get a workers' comp attorney involved with your case. It's just because sometimes when we tell people, I think you're okay, sometimes those folks, they run into like some kind of, or they're doing okay and then they do need an attorney. It might be that they're doing okay and then, months down the road, oh, my condition that I requested is being denied. Now I need an attorney. That might arise. But in general, even if you think you're doing okay, well, you need to talk to an attorney. So ask your family, friends, coworkers, neighbors, etc. Who do you guys use? Who do you guys recommend? And consult with that attorney. And then, frankly, I'd recommend you hire an attorney. Worst case, you're going to have somebody, or if the situation is, if everything's going great, your attorney still in the background, they're going to be monitoring your claim. They're going to be making sure bills are paid, etc. So get an attorney involved if you have a work injury. So you've been listening to Kip and Malek and Malek. If you have any questions, concerns, whatever, leave them in the comments or call my office or email me, and then I will address them, or I will attempt to anyways. Stay safe, and I appreciate you listening to this. Have a nice day. Thank you.